Okay, so today is the second session in the 11-part series on family law in Arizona. Here in our office, we have people for the free seminar, and we're live for anybody who has questions on Facebook. Now, if you do have questions on Facebook and you want it to be anonymous, you can go ahead and send those to us via text. And you can text it to our main line, and we'll put that number in the contents, or email us, however you want to get us that information. So last week we talked about attorneys, how to find them, how to interview them, what information to bring to your initial consultation, how to know if you have a problem with the attorney that you're working with, and whether or not you should consider switching attorneys, the value of second opinions, that sort of thing. Today we're going to talk about fees. How much does it actually cost to get divorced or go through a family law case? And now when we say divorce, it doesn't have to necessarily be divorce. It could be a custody case or a modification case. But how much does it cost? How can you save money? How can you do it yourself? What are all of the different options for you to utilize technology like artificial intelligence and online forms and those services, flat fee options, and limited scope options? And we're going to try to get through this by the time we're done at 1, so you can go back to lunch, but it may go over a little bit more. Over the next coming weeks, here are the other topics that we're going to be discussing: disclosure and discovery, RMCs, resolution management conferences and pre-hearing conferences, return hearings, how that works, negotiation strategies and tactics, trial preparation and presentation, and then that's kind of the procedural nuts and bolts of the case from start to finish, how to file your petition, everything like that. And then after that, we'll go into the substantive legal issues, the kiddo issues, the divorce legal issues, child support, spousal maintenance and alimony issues, property concerns. So how much does it actually cost to get divorced? So anybody here can tell you there's a wide range of what people pay, but the average statistics is that people spend roughly $20,000 per person. That's not true here at Modern Law. We have run the numbers, and our clients spend on average about $6,500, which is something that we're really proud of and intentional about. We don't want to charge anybody money that they don't need to spend, and we want to find the most efficient way to get people divorced. But the general question is, how much does it cost? And the general answer is it can be $20,000 on average. Why are you smiling over there? Because. And some people can get divorced for as little as $500 or less. Now that largely comes from the court having fees. Now those fees that the court charges can even be waived if you qualify income-wise. So massive disparity in what you might spend. And we're going to talk today about how you can influence how much you need to spend and how you can be as efficient as possible with your budget. Obviously, the lowest cost divorce are going to be those where you do it on your own. You're not using an attorney. That's best when you don't have children, you don't have property, maybe you don't disagree on anything. There's really not a lot of reasons to spend money on an attorney or even a paralegal or a doc preparer at that point. And then let's say that that's not you. You're not in the category of everything you agree on and there's no children, no property. You've got some issues, but you still really want to stay on a very tight budget. Then you might look at a mid-range options like using a certified legal doc preparer here in Arizona, or using an attorney on a limited scope basis, which means using that attorney for some of your divorce, but maybe not all of it. So for instance, getting assistance with drafting paperwork or with preparing for trial, that sort of thing. And the way that I recommend you go about making this decision is by doing a cost-benefit analysis. And we're going to go through these slides and talk about how to do a cost-benefit analysis based on your reality. How much should you spend? This is a good question to be asking yourself because the answer is not the same for everyone. You have to begin by examining what your issues are. So think about all of the issues that you could potentially have in your case. Do you have child custody issues? Do you have property issues? Do you have debt issues? Do you have alimony or spousal maintenance issues? If you do, then we need to, the next step is, okay, on child custody, what do we disagree about and what do we agree about? if we agree on everything in child custody, then maybe we can set that off to the side, and then move on to the next massive issue, and maybe that's property division. Maybe the two of you own a business together, or you have massive debts, or there's like $400,000 in student loans, $200,000 which you used to live on during medical school, and you're arguing over how that's going to be split up. The numbers here matter, because if you're determining that property division is a massive issue, you have this business, let's say it's a medical, a dental, or a medical practice, and you've got all these student loans that came from, putting your spouse through medical school, and you used all of this money to, live on, and now you've got this medical practice. How much could that be worth is the next question. If that could be worth, in this case, it could be worth a lot, it could be worth millions of dollars, then what is the benefit and the cost of using an attorney to help you with that issue? Obviously, if we're talking about millions of dollars on the line, then the cost of using the attorney, let's say it's $20,000, is going to be minimal compared to the potential benefit of reaping your millions of dollars in equity in your medical practice. So if that doesn't make sense, anybody let me know. Does that make sense?
Yes.
Yes? Okay, so in another example, let's say we're talking about alimony. You make $20,000 a year, and your spouse makes $400,000 a year. Your spouse does not want to pay any spousal maintenance. You can't pay your bills without it. At that point, you want to do a cost-benefit analysis, get some information to figure out realistically how much alimony might I be able to qualify for, over what period of time. What is that total number, and then what is the cost going to be to secure the alimony or the spousal maintenance that I need? Now, the next step is, okay, first you've looked at your issues, and you figured out, okay, what are the issues, and how much is on the line for each issue, right? And with child custody issues, it's more difficult to assign a number, but nevertheless, you should go through the analysis where you're thinking, okay, my spouse is very abusive and can't be around my children. The value on that is high, even though it's not a dollar amount. So you would really want to think long and hard before deciding whether or not to use an attorney. And within all of these issues are sub-issues, all of these sub-issues, and you can check those sub-issues out in online or in Modern Law's book, Decode Your Divorce. So the next thing that I recommend you do after you look at all of these issues and all of the sub-issues and determine how much is on the line, what's at stake, is you determine what is the range of outcomes that could happen with each particular issue. So I'm just going to go back to this slide. So let's say we've got this family business. What is the range of options on the medical practice? You're probably, without some information from an attorney, that's probably not a great example. Let's think about your house instead. You can figure out pretty easily how much equity is in your house. And if you bought the house during marriage, then the house is community property. If you've got $100,000 of equity in the house, what's the potential range of outcomes there? It's not that wide, right? We might be fighting at that point or arguing over, is it $100,000? Do we take out realtor fees? Is it worth a little bit more, a little bit less? If the range of outcomes is very narrow, that's something we want to look at when you're making your cost-benefit analysis of how much to spend on an attorney. Likewise, if you're talking about this family business and the range of outcomes on how much it could be worth worth $100,000 or $3 million, the range of outcomes is massive. So, or if we apply that to custody, let's say you don't really like your spouse, you don't want your spouse to have equal parenting time, or your ex-boyfriend or whatever. You don't want him to have equal parenting time. You want him to have 30% parenting time, and he wants equal percent parenting time. Okay, your range of outcomes is somewhere between 30% and 50%. How much is it worth to you in terms of dollars and resources in order to end up somewhere between your 30% parenting time to 50% parenting time? So what I'm advocating is a pretty intentional analytical process before you decide whether or not you necessarily need an attorney or how much you want to spend on that attorney. Okay, any questions on that?
Just sounds like a lot of a lot to go through while you're kind of emotionally spent to try to like really put a number, because like when you're really emotionally there is, I don't know, it just seems like it could be a little difficult to actually do what you're asking.
Yeah. Well, you bring up an excellent point, because we as lawyers, and what I'm conveying to you now is a very analytical, non-emotional, detached approach to decision making. And we don't work that way as humans. We just don't. We make decisions based on emotions all the time. So how do we factor that in? How do we make that work for us? Get help, talk to family and friends, try to get assistance when going through this analysis, whether it be from an attorney or somebody else that you trust that can help you kind of take a step back. And the other reason that what you're saying makes so much sense and is so important is because there is value in seeing an attorney simply for the emotional relief they can provide, which is separate from this whole cost benefit analysis. Maybe, yes, you are talking about between 30 and 50% parenting time, but the emotional relief that you're getting from having an attorney take over your problem is worth $10,000 to you. That's legitimate. That's not an illegitimate thought process. That is a logical, rational thought process. But what I'm talking about is thinking about it and putting a number on it and deciding, do I have $10,000 and is that worth it to me? But great question. Any other questions on that? No? Okay. So after that, let's say you've gone through this analysis and you've decided what's the potential range of outcomes and what are my issues. Okay, you're going to assess your financial position. How much money do I have available to me? And what must I do with that money? If you're going through a divorce, you're talking about getting a new house. If you're getting a new house, then you need to get new stuff. You gotta move stuff. You gotta buy boxes, right? I mean, there's a lot of other things that come with going through this process that aren't just paying a lawyer. So part of assessing your financial position is your budget and your needs currently. And a lot of people have other people that help them financially through this. Parents often help out their children who are going through a divorce or family law custody issues. So assessing your financial position isn't necessarily only yours, it's the entirety of your resources. The next thing you need to do is protect yourself financially and emotionally. That's something you need to be thinking about sooner rather than later. How do I make sure that I'm protected? Protecting yourself financially means not spending too much money. If you cannot afford to go spend $10,000 on an attorney because you need to move and you have nowhere to live, then by all means don't do it. And I can't tell you how many times I've had people in my office saying things like, I don't have any money I'm not getting any money for spousal maintenance, and I want you to file something. And you don't have money to pay your rent. You're telling me you're going to get kicked out of your house and you want to pay me this is not a good use of your resources. So protecting yourself financially and emotionally means making analytical decisions based on that as well. Decide what is your best and worst case scenario and what can you live with. If we go back to the custody situation and you've got, okay, I really want my ex to have the kids 30% of the time. He really wants 50% of the time. Can you live with 50% of the time? Can your kids live with 50% of the time? How bad is it? Before you decide to go spend your $10,000 or your $20,000, let's really think about best case, worst case, and what can you live with. And then next is build your support team. And your support team, we talked about this a little bit last week. This is your legal team, but also way beyond that, your friends, your family, and who are you surrounding yourself with? Who are your friends that you are allowing in your inner circle right now? Because they may not be the same friends that you party with on Friday nights. Getting a call from the kiddo. All right, so you've gone through this exercise, and now we are determining what are the costs, how am I going to pay for it, and this question really comes down to two things. What are your representation options, and what are your funding options? We talked a little bit about this at first, but let's dive into them a little bit more. You've got like a DIY or paralegal option. That is, you're going to the courthouse and you're filling out the forms yourself, or you're seeing a certified legal doc preparer who helps you do the forms. The other option that you've got is going online to a place like LegalZoom or using accesslegaldocs.com, which is our sister company, Access Legal, which has online options. Then you've got an alternative use for attorneys, where you're using them on a limited scope project basis, but not handing over a retainer and saying, do everything. And then the traditional approach is, what we do most often. And it's kind of the full service concierge, wrap you in a bubble, take care of all your problems approach. And all of these have pros and cons. And I think we just need to be realistic about what those are and who you are. And part of this analysis is you going through deciding whether or not you want to do it yourself and whether or not that's worth it to you. But doing it yourself is possible. People do it all the time. 80 to 90% of people at some point or another in their family law case are pro per in Arizona or pro se in every other state, which means you're doing things yourself. Sometimes it works out just great. Other times it is literally disastrous. I think I talked last time about the person who did her own divorce, and she was fairly happy with the outcome, except for that they didn't address the $200,000 that was owed to the IRS, or other, just massive holes because they had a business and they didn't talk about, how the payout would work and interest. And so, anyway, the bottom line is, if she had done this analysis and truly determined what is potentially at risk and had people around her that could help her do the analysis, she may have made a different decision about getting a little bit of advice going through that. Now, can you do it yourself? Well, these are some questions you can ask yourself to determine if you're a good candidate to do it yourself. Are you on time? Do you meet deadlines? Are you somebody who has a hard time kind of keeping track of deadlines and extra projects? Or are you like super type A and like everything is done and everything is right? Those people tend to do a better job themselves than people who are more type B, who are like, I'll get it done if I can, when I get to it. Do you have the time to make this happen? What position are you in right now as far as time and resources available to you? Did you have a question?
I do. If I do it myself, is the judge gonna hold me as accountable on these things if I mess up since I don't have an attorney?
That's such a great question. The rules say yes. The rules say that the pro per litigant should be held to the exact same standards as an attorney. Sometimes that happens, sometimes it doesn't. Depends on the judge, depends on the day, depends on the issue. So that's a terrible answer to your question, but that's the truth.
Okay.
Do you do your own taxes? Some people can file their own taxes and do a fantastic job. And the forms that we're doing in family court are not unlike the forms that you're doing when you're filling out forms that go to the IRS. So that's something you can ask yourself. And do you keep your cool under pressure? Do you feel okay speaking in front of people and articulating yourself on something that is, pretty darn emotional? Where are you at emotionally? Assess yourself. Truly assess yourself before you decide if you are a good candidate to do it yourself. Now, red flags. If you are one of these people that believes that rules are for other people but really don't belong to you, or you think that you're more of the person who's thinking about how life should be than how it is, like, you're gonna be disappointed. Are you somebody who flies off the handle? Are you somebody who doesn't like speaking in public or has a hard time articulating yourself or shut down? Or do you have a hard time talking to your ex, or are you guys on fairly good terms where you're able to come to some agreements yourself? All things that you should be considering when making this decision. Now, you can always start out with trying free or low-cost resources and then decide along the way that this isn't working. You don't have to have the answers all today, and you can change your mind. Do not feel like you are locked into any particular attorney or any particular course of events. As your litigation or your case goes forward, you're going to want to be thinking about pros, cons, and what's the best for you today, given changes in your situation. If your divorce is complicated, it involves property issues, business issues, or difficult circumstances with custody, you probably need to at least see an attorney at some point. You would benefit from the advice that you would get from an experienced practitioner. And so even if you decide that you're not going to end up using an attorney for everything, please go see somebody at some point. What can you expect to spend if you go to an attorney? Typical attorney fees are anywhere between $250 and $350 an hour on average. You will find attorneys who charge less. You will find attorneys who charge more. Paralegals are typically between $80 an hour and $180 an hour. And administrative costs or charges are usually between $60 and $100 an hour. And again, those are averages. What's important is that you look and you understand what the financial arrangement is with the attorney that you're working with. They will most likely give you a written fee agreement, and you're going to want to take the time to go through that carefully to understand what it is that you're doing and spending. Now, with limited scope representation, you are paying only for what you need and the projects that you have contracted for. This can be challenging because people who end up with limited scope representation don't always know that they've signed up for limited scope representation, and many times people who have entered into limited scope representation agreements believe that things are included that are not, or the attorney and the client haven't come to a very clear understanding about what's included and what isn't. So the most important thing in my mind, if you're using limited scope representation, which, by the way, as an aside, I think is a fantastic option for many, many people. It's something to really consider. But what's most important here is to make sure you understand what's included and what isn't. Be prepared to do some of the work yourself. If you think that your attorney is just going to answer all your questions and be there available for you night and day and do whatever needs to be done in your case, you don't have a limited scope representation agreement. So really think about that if this is the choice that you've made, or this is the option that the attorney has presented to you. Your costs can be reduced. They aren't necessarily reduced. That depends on how much you hire your attorney to do for you. But they are a little bit more set and a bit more predictable, which is a great thing. Flat fee, go ahead.
Would it be in my best interest to track deadlines on a limited scope basis just to ensure that I'm not missing things? You know, if there's any confusion in between what is my responsibility and what I've hired an attorney on a limited scope basis responsibilities to do, or?
That's a fantastic question. Should you, and are you responsible for tracking your own deadlines if you have entered into a limited scope agreement? I mean, unless that limited scope agreement says, I will track all the deadlines for you and tell you about them, yes, that is on you, the client, you, the pro se litigant. And at the same time, I would tell any attorney who's providing limited scope representation that you should be tracking deadlines and communicating it. But just to protect yourself, yes, that is something you should absolutely do. Flat fee divorce options are a little bit different than limited scope options, sort of, because usually with the flat fee divorce option, it's like a limited scope, but not really, because they're doing it all for you. So you've got predictable fees, you know what you're spending, and the contract is that they're going to do it all for you. Even here, you're going to want to really outline the parameters of what's included and what isn't, because what if somebody files for an order of protection? It's kind of related to your divorce, it's not really in your divorce. What if somebody files an appeal? Kind of related to the divorce, it's mid-divorce, you could do a special action. There's still a lot of what ifs that may or may not be covered. So the most important thing here is communication. Now with our particular fee agreement, our fee agreement that we use most of the time has flat fee pieces built into it, so that you know exactly, when we go to court for a 1 hour hearing, this is how much you're going to spend for that. Regardless of whether or not the hearing goes over, goes under, this is the cost. So we have as many flat fee options built into our agreement as possible, which gives people the ability to pay hourly for things like communication and meetings that you may need, or extras for things that come up, like we're just talking about where the appeal comes up, or the order of protection comes up. And it doesn't mean that you have to hire us to do it, but you have the option to do it, and you know the terms because of the fee agreement. But you also have the flat fee stuff built in. How can you pay for your attorney? Well, there's a lot of ways to pay for attorneys. People can use cash or savings. People can take money out of their retirement accounts. People can use credit cards. People can borrow money from family, friends, or third-party funding agencies. They do exist, and we know quite a few clients who use them. Other people will take a class and take out some student loans and do it. There's a lot of ways that you can. Oh my gosh, we have had clients that have used GoFundMes or borrowed from churches. I mean, there's a lot of ways that people can fund whatever their particular project is. Now, what are some other ways that you, if you're working with an attorney, can keep your costs down? Be disciplined in your communications. Do not reach out to your attorney every time you have a thought. It will simply be too expensive. Save up your thoughts. And remember when we talked about gathering resources back in the beginning? Another exercise that you could go to would be thinking about, what are friend questions and what are attorney questions? And the line isn't always clear. I mean, I also talked last week about how learning about somebody's sex life led to an annulment instead of a divorce and saved all this money. So I'm giving you contradictory information here. I understand that. But anyway, be disciplined in your communications. Don't reach out every 5 minutes. Save them up for maybe a weekly email or something like that. Get organized. People spend so much money they don't have to spend by not being organized and not having their paperwork together. So get help. If you are not an organized person, and it is okay, I mean, let's be honest, not everybody is super organized. If you're not an organized person, then who are your friends that are super organized who can help you? Because they are going to be cheaper than attorneys or paralegals at getting your stuff organized. And we will tell you exactly what you need to organize. And if you're not working with us, then you can still buy Decode Your Divorce, or you can come by the office and we'll give you one. And it will tell you exactly what you need to get organized. Remember your objectives. Remember the exercise you went through at the beginning of this little talk about what are my issues and what are the potential outcomes and what can I live with. Remembering those objectives, writing them down if you need to, posting them in your bathroom will help you make good decisions based on what is actually important to you, not the moment, the current fight or the flying off the handle. Make sense, everybody? Okay, almost done with this. That's it. Now it's time for your questions. What other questions do you have?
So if you sit down and you do this cost benefit analysis and you look at all the factors, and you determine that you probably really don't need an attorney, there's not going to be many issues, we're semi-communicative, is it still possible for things to blow up where you could get an attorney later?
Yes, absolutely. And I think that's a great point. I mean, if you are, what you just described, let's say you're at the beginning of your divorce and you and your spouse are working really well together, then by all means, start there and understand that if things change along the way, you always have options.
So what can I do though if my ex isn't represented, but I'm getting ready to get represented, but I know that as soon as he finds out, he's gonna just start trying to run up my bill. Like, I do have limited funds and I know that I need help. Like, I've done this analysis and I'm not capable of representing myself efficiently or effectively. Like, what can I do to try to protect myself from that?
That does happen. There are opposing parties who understand that, you as the client get billed every time they contact your lawyer, and they will literally harass your lawyer. Now, you need to ask your lawyer to help protect you. There are ways that I've done that in the past. At one point, I had an opposing party that was literally harassing me to get to his wife, and there was an order of protection in place, and he knew exactly what he was doing, and I knew exactly what he was doing. And at one point, I told him, I just called him out on it. So you are trying to use me to harass your wife, and I will not tolerate it for a moment. And if you don't stop, I'm going to file an injunction against harassment myself. You can ask that person communicate only in writing. You can block their email address. I mean, ask your lawyer to help you out. Your lawyer should come up with some creative ways to make sure that doesn't happen. But it is a great question.
I have a quick question.
Mm-hmm.
So at this point, me and my husband, it appears that we've reached agreements on everything, but just to ensure that I'm not missing anything, would you recommend that maybe it might be worth, because I don't have the $6,500 to pay, an attorney to walk me through this, but because I believe that we're in agreement with everything, would you still recommend that maybe I pay for a consult with an attorney, just have like a meeting of the minds and, just make sure I'm not missing everything and that
Yes.
I'm set up for what's best.
Absolutely. I mean, your situation is so common. You think you've got everything worked out. You guys have designed your parenting plan. You come in, you show it to us, and then we say, well, wait, what are you doing about, summer vacation? And what are you doing about transportation? Where's transportation happening? Our job is to issue spot and to help make suggestions based on what's worked and what blows up for other people. Like, for instance, those in your situation, people will come and they'll say, well, we don't need to be specific in our parenting plan because we agree on everything. The parenting plan is for when you don't. for when your ex marries this woman that you hate and she has her own kids and she wants to run the show. That is why we take the time to build a really proactive, detailed parenting plan in advance that addresses as many issues as possible. So yes, even if you agree on anything, please come see us and let us help you, even if it's for an hour. Any other questions? Okay, I know that we saw a bunch that came in, a bunch of stories that came in throughout the week. So I don't know if you can pull those up.
So here's one that came in. My wife moved out and stopped contributing to our bills. I don't make enough to pay for everything myself. Can she do that? Isn't she responsible for contributing so that we can continue the lifestyle we established during the marriage? She can't just refuse to pay for things we've always done. My daughter has certain, piano, my son has football, but she says that she's just not going to pay for that anymore. So what can I do?
Okay, so this was a written question, so I can't really ask any follow-up questions.
No.
But you've got a couple, they're living together, they have a certain established lifestyle. One spouse moves out, they are theoretically, they have their own expenses now, and the other spouse has been left with all the community bills, right? The mortgage, the utilities, everything. What can you do? And then what you can do is you need to file for divorce, because until you file for divorce, the court has no jurisdiction over your marriage or your life. So you can pretty much do anything you want to while you're married. Anything you want to. You guys can run your marriage how you want to. You can have separate bank accounts. You can have one spouse pay for everything and the other spouse take their money and, gamble it and buy makeup, whatever. It doesn't matter. So if you want the court to get involved and start issuing orders for anything, you have to file for divorce. And then what you can do after that is file a motion for temporary orders and ask for temporary support or a temporary order that says who's going to pay what bills, because you need to make sure that all of those community bills get paid. Now, the second part of that question was, my daughter has piano.
There's certain expenses that are for the children,
Sure.
but she's refusing to also pay those.
Yep. Okay. So temporary child support is also something that you can and should file for. Child support is figured out with a calculator. Both people's incomes go in, the certain expenses go in, and then there's a child support number that's spit out, and it's not really optional. It's money that's owed for the benefit of the kids. Now, are you going to be able to maintain the exact lifestyle that you did while you were married? Probably not. I've met very few people who are able to have the exact lifestyle they had when they were married when they're also separated, especially when they're going through the divorce. The process of divorce is expensive and it really taxes your resources, and things usually have to change, or people end up in massive amounts of debt. So you may be entitled to temporary spousal maintenance. You're not likely entitled to maintain the exact standard of living that you had when everybody lived in one house.
So one other question that came in that is a little bit intriguing as I was looking through these. For several years, we didn't choose to vaccinate the kids. Now I'd like to have them vaccinated. Do I need permission? Would a judge require my kids to be vaccinated because my wife is refusing to vaccinate?
Mm-hmm. Yeah, we've had this come up before. Kylie, do you want to tackle this one?
Yeah, this is kind of a messy topic, and a lot of times it's a roll of the dice, and it depends on what judge you get. If you are on the side of not vaccinating, you're probably going to have a much tougher battle to win this in court. If you're going to choose to fight this, I'd recommend getting a number of professional, whether it's doctors or scientists, anyone that can come in to back up your claims, because it is going to be a really, really tough one for you to win on.
Yeah. Yeah, the other thing that I think matters is this a modification, or is this the first time that we're coming before the judge? Do we have an agreement in place that showed that the parents agreed not to vaccinate? And then the other question is there a legal decision-making order in place? Because legal decision-making is, okay, so Arizona has done away with the term custody, which is sort of confusing because the other 49 states use the word custody. But the reason that Arizona moved away from it was because custody means two things. It means physical custody, where are the children? And it means who makes the decisions. So Arizona said, well, we're not gonna call it custody. We're gonna say that we've got parenting time and we've got legal decision-making. Legal decision-making only covers 4 major things: medical decisions, school decisions, religious decisions, and personal care decisions. And I don't exactly know what personal care decisions are. Maybe they're like braces and piercings and hair. Like, I don't know how people dress, social media. I don't know. Be nice if the legislature to find that for us. But anyway, so if there's a legal decision-making order and one parent has, let's say, the final decision-making ability on medical, they will probably have the ability to decide whether or not those children are vaccinated. Or if one parent has sole legal decision-making, they will probably be able to make that decision.
And just to step in there too, sometimes I've seen some parents that can come up with some creative solutions to this too. You know, they might agree that only certain vaccinations are going to happen, or the other parent's going to get to do some sort of protocol, whether it's certain vitamins or things like that they take before or after the vaccination. So there's different ways that both parents can at least benefit from this a little bit.
Yeah. The other thing that I've seen sometimes with medical issues is parents might have an agreement that when there's a disagreement on medical issues, they'll defer to their doctor that they chose together. Or so we gotta get creative because these are tough, and these are issues that I never like to take in front of a judge because I think you really are rolling the dice, especially if you're the anti-vaxxer.
So, sort of a follow-up question that just off of what you guys talked about, not actually from the person, but if, let's say, there was an order in place that, dad gets to be the final decision and he wants to vaccinate, but mom doesn't. If mom catches wind of that though, and she files for a modification, does that mean that dad can't vaccinate until something, does that put any hold on his ability to do it?
It really doesn't.
I'm just curious.
I mean, unless you can go get some emergency order. And I mean, let's say mom, I don't know, I'm just making this up. Let's say mom, who is a real fan of plastic surgery, decides to get her 16-year-old a cosmetic breast reduction and lift. I could see that situation where dad might be able to go in and say, whoa, I need an emergency order preventing this until we can discuss this further, even if mom had. I mean, I don't know. What do you think, Kylie? Do you think that might work?
I think it might, especially when you're dealing with significant surgeries and things like that. Whereas maybe a vaccination, it's probably not going to impact them that much right at the moment. But if they're going to be put under and things like that, I think that the court has to consider that.
Actually, we did have a case like that once. Remember when we had a little boy and the dad was taking him in to get a feeding tube, and we tried to get an emergency order preventing the surgery because mom didn't think he needed this feeding tube, but I don't remember what happened.
I think it was a little bit after that.
Okay.
So he had the feeding tube in him, but we did get an emergency order, and they ended up taking the kit from dad and giving the kit to mom because he had not consulted her about getting the feeding tube in or anything like that.
Medical issues are so interesting. It's a great question. It absolutely comes up. So we only have a few more minutes before 1 and everybody has to get back to lunch. But do we have any other questions either here or that came in over the last week or so? Not over the last week. Any questions here? No? All right. Okay, thanks guys. We'll see you in a couple more weeks. Have a Merry Christmas.
Thank you.
And Happy Hanukkah. I think it's Hanukkah right now, right?
It is.
Yeah. Did you already stop Facebook?
No.
Thanks for lunch.
Bye.
How to use the restroom, and there was someone really awkward in there.
What?
Didn't get me.
Really?
I don't know. There was